Welcome back to a new post today. Let's today discuss the most important points of analysis with regard to the Waqf Bill, which is being discussed and now voted in the Parliament. So it has also submitted to a joint parliamentary committee consisting of the members of the Lok Sabha and the Rajya Sabha, and there have been some criticisms with regard to the bill. Let's look into this one by one. So as we know that Waqf is a word that means voluntary, permanent, irrevocable dedication of a person's wealth in cash or kind as charity that is recognized by Muslim law. The concept of Waqf arrived in India with the advent of Islam, and it refers to permanent dedication of one's movable or immovable property for the purposes of charity or piety enshrined in Islam as religious or charitable. Now Waqf came into India. So in India, with the advent of the Delhi Sultanate, in India the history of the Waqf can be traced back to the early days of the Delhi Sultanate when Sultan Muhammad Sam Ghori dedicated 2 villages in favor of Jama Masjid of Multan and handed over the administration to Shaykhul Islam. As the Delhi Sultanate and the later dynasties flourished in India, the number of Waqf properties also increased in India. In India, several properties fall under the Waqf like mosques, Eidgahs, Dargahs, Khanqahs, Imambaras and also Qabristans, which are graveyards. Waqf properties once donated by the followers of Islam are managed by the community and these are irrevocable. That means they cannot be taken back. Each state has a Waqf board, which is a legal entity that can acquire, hold and also transfer the property. Waqf properties cannot be sold or leased permanently. There have been various acts in India to regulate these Waqf properties, and there have been instances where decisions have been taken to abolish these Waqf as well. As early as in 19th century during the British rule, a dispute over the Waqf property ended up in the Privy Council of London hearing the Waqf and hearing the case and calling the Waqf property in India as the worst and the most pernicious kind and declared Waqf to be invalid. However, the decision by the 4 judges was not accepted in India, and the Musalman Waqf Validating Act of 1913 saved the institution of Waqf, and since then no attempts have been made to curb the Waqf. Presently, about India has 8.7 lakh properties spanning 9.4 lakh acres in India with an estimated value of 1.2 crore rupees according to the government data. And the Waqf board is the largest owner of land in India after the armed forces and the Indian Railways, making it the 3rd largest owner of land in India. So there are the Muslims. From where do the minorities or the Islam religion people get these rights? These rights are enshrined in the constitution under Article 26, under Article 29 and 30 as well, where they can acquire movable and immovable property to administer institutions for their with regard to minorities. And the government, we already have a 1995 Act which regulates and administers the Waqf property in India. Now this 2025 Waqf law amends this very law of 1995 to bring about better regulation, administration and management of the Waqf properties in India, and this is what the government of India says. So the reason why the government of India thought of bringing up a Waqf bill is to bring down litigation, ensure transparency, efficiency in governing of the Waqf properties. It also wants to deal with illegal occupation of the Waqf land, and major issues flagged by the government are like diversity, the misuse of the powers by the mutawalis who take care of the Waqf property, lack of effective coordination with the local revenue authorities, and sweeping powers enjoyed by this Waqf board for claiming properties, resulting in disputes, litigation. Therefore, the government thought to bring about a new law. The major concern among the critics is the government's intention to control the Waqf properties by regulating the management and the power that it gets through the new bill to determine whether or not a property is a Waqf. So what are the changes that are brought in? And for the very first question before going into the changes is, can the parliament enact a law on this? Yes, if you look at the list of legislation under the union, state and concurrent list, charitable and religious institutions fall under the purview of the concurrent list of the Constitution. Hence, both the state and the parliament have the powers to frame a law. It also says that if the parliamentary law has better features than the state law, and in case of incongruency, then the parliamentary law prevails. Otherwise, it's the state law prevails. And if there is a legal dispute between a state law and a parliamentary law with regard to concurrent list, if the state law gets a presidential assent, then the state law with regard to the same subject will prevail, and therefore the government gives higher the preference to the parliament. But in case if the president gives an assent to the state law, the federal law will prevail. Now, currently, creation and management of Waqf Act is governed by the Waqf property in India is governed by the Waqf Act of 1995. The act was preceded by many legislations like the 1913 one, 1923 and 1954, and states like Uttar Pradesh and Bengal have also separate laws governing the Waqf. However, these were repealed once the 1995 Act came into being. Now, a waqf or a charitable donation of movable or immovable property, whether cash or and even cash or kind, can be created by declaration of property through oral or written deed, long-term use of the land for religious and charitable purposes, endowment upon the end of the line of succession. And the creator of the waqf is the waqif. That is, the person who gives away his property is called as a waqif, and it is managed by an administrator called as the mutawalli. Now, the states with the highest share of the waqf properties in India, the three highest are Uttar Pradesh, West Bengal and Punjab. Uttar Pradesh having 27%, West Bengal 9% and Punjab 9%. Several committees have administered the state of the Waqf properties in India, and they have highlighted various issues like unrealized revenue potential of these properties, encroachment, poor maintenance, pendency of cases in the Waqf tribunal, and also lack of transparency and inefficiencies in conducting the surveys as well. Now, the Waqf Amendment Bill was introduced in 2024 by the Minority Affairs Minister in August 2024 after the new government, Kiran Rijiju. Now, it aims to amend the Waqf Act of 1995 and revises the composition of the council and the board, creating criteria for forming of a Waqf, and also powers of the board to identify the Waqf property as well. The bill was given to a joint parliamentary committee which was chaired by Jagdambika Pal. And the key features are that it defines the formation of a waqf. Now, the bill states that only in 1995, the 1995 bill allows the waqf to be formed by declaration, recognition based on long-term use by the user, and endowment when the line of the succession ends, that is, a heir or the male successor ends. Now, the bill states, now the recent bill of 2025 says that only a person who practices Islam for the last 5 years can declare a waqf. Now, this change has been brought because of an amendment brought into 2013 law, which says that any person who is a non-Muslim can also give property or wealth as a waqf. Now, this is brought because of that. It clarifies that the person owning the property must own the property being declared, and that means the person who is giving it must own the property, and it removes waqf by user, which is in 1995 Act. It also specifies waqf alal or the aulad must not disinherit the heirs, and female heirs must be given the right over the properties. The survey, who surveys the waqf land? According to the 1995 Act, the survey commissioner is appointed for surveying the waqf properties, but the bill replaces the survey commissioner by a bureaucrat who is the district collector now. Now, the next is about the government property as waqf. The 2025 bill clearly states if any government property is identified as waqf, it will cease to be a waqf, and the collector of the area will determine the status of this property, and if it is government property, it will cease to be waqf property. It speaks about the Central Waqf Council. The 1995 Act says that the union minister in charge of waqf will be the ex officio chairman, which is the Ministry of Minority Affairs. The members of the council will be members of parliament, persons of national eminence, retired Supreme Court judges and High Court judges, and eminent scholars of Muslim law. The 1995 Act says that apart from the chairman, all the council members must be Muslims, and at least 2 must be women. This composition is changed by the 2025 bill. It says that it does not call for the members to be Muslims. It provides for for the allowing of non-Muslims to be a part of this, and further mandates that 2 members must be non-Muslims as well. The composition of the Waqf board is changed by the 2024 bill. The 1991 says that there is election of the members of from the electoral college of the state's Muslims, MPs, MLAs, MLCs, bar council members to the board. This 2025 bill changes the nature of appointments to nomination and not election. The state government will nominate 1 person from each of the above groups to the boards. They need not be Muslim. This is what clearly is said in the bill. And it adds that the board must have 2 non-Muslim members, at least 1 member from Shia, Sunni, backward classes of Muslim, and the 1995 provides that there must be at least 2 women. This is not changed in the 2025 bill. Now it also changes the composition of the tribunals who will look into the dispute of the Waqf property. The tribunals constituted under the 1995 Act included a judge of the rank of equivalent class 1 district session magistrate or the civil judge, a state officer equivalent to the additional district magistrate, and an expert in Muslim law, because the Waqf is something which comes under the Muslim personal law. Now the 2025 bill removes the expert of Muslim law in the tribunal and also says that the decisions of the tribunal are not final. They can be appealed in the High Court as well. And appeals in the High Court will lie within 90 days, bringing out a timeline, also a deadline for appealing in the High Court as well. So the orders may be appealed in the High Court within 90 days. So what are the criticisms with regard to this? Number 1, first of all, the composition of the Waqf board. Now it proposes a non-Muslim chief executive officer and 2 non-Muslim on the Waqf board in the states. Critics say that this interferes with the Muslims community rights to manage its own affairs under Article 26 of the Constitution, reducing Muslim representation in the Waqf governance when it is provided by the Constitution itself. Article 26 provides the fundamental rights of religious communities to administer and manage their own affairs. It also speaks about non-Muslim members in the Waqf Council and the Waqf Board. The bill alters the composition to mandate presence of non-Muslim members. It also permits non-Muslim members to be a majority now in the Waqf Council and the Waqf Boards as well. And under this, 4 to 8 members of the state Waqf board will be elected. 4 are nominated, 4 were elected previously, but now they will be nominated by the state government, bringing in the authority of the state government at that time to choose the members. And under the under the Act, the Central Waqf Council will be chaired by the Union Minister. Barring the ministers, all the council members will be Muslims. The bill puts an end to this. So the members of the council will be non-Muslims. So the bill leaves rooms for 12 members out of the 22 council members to be non-Muslims, bringing a majority authority in the minority affairs. And also it speaks about the chief executive officer need not be a Muslim. So usually under religious institutions, the parliament provides the power to these institutions to appoint members of their own community in managing. But the bill changes this. Under the Act of 1995, the state government required to appoint a chief executive officer to the state Waqf board, and he has to be a Muslim. The bill requires the CEO to removes the need for the CEO to be a Muslim now, and therefore brings about. If you look into the other act, the Sikh Gurudwara Act of 1925 provides that all the members of executive committee must be Sikh. All the members of the board should be Sikh as well. And the Andhra Pradesh Charitable and Hindu Religious Endowments Act provides 13 out of 21 members of Andhra Pradesh Dharmika Parishad should be Hindu. The chief executive officer must be a Hindu as well. So these are the changes brought out in the Waqf board. Apart from that, they also remove the Muslim expert. Waqf is a Muslim personal law subject, but they remove the Muslim expert from the tribunal, therefore ending Muslim personal law authority on the Waqf issue as well. Waqf, I told you, is a permanent dedication of property for the purpose of a charity or religion which is pious in Islam or under Islam, and therefore irrevocable as well. It also says, now in 2013 there was an amendment brought in 1995 Act which widened the scope of the Waqf to include property dedicated by any person irrespective of being Muslim, that is including the properties of non-Muslims as well. 2024 strictly says that the Waqf creator must be a person who has been practicing Islam for at least 5 years. Now, analysts say that this is a clear violation of Article 14 of the Constitution. It allows two classes to be treated differently only if there is a clear public purpose being served by such differentiation. Apart from that, if you look at the other countries in the world, Malaysia, Indonesia, Bangladesh, UAE, Muslim countries, even they have national laws on the Waqf. In some countries, in Malaysia, the states have Waqf laws and they have authority or rights on these lands. And Indonesia, Bangladesh and UAE have national laws on this. So the situation varies from country to country as well. So these are some of the points that I wanted to share with you and analyze why exactly there's been criticism. And recently the Kerala Catholic Council has supported the Waqf because in a Manambakam case, some property of a private person was taken over, calling it a Waqf property, and therefore there is a criticism that many of the people's private property and many non-Muslims properties have been taken away and bringing them under Waqf, or where there is no need for a written deed, and if you just give them by spoken words that this is a Waqf property, the user can claim that this is a Waqf property. So similarly, many private persons properties have been taken away. This is one of the criticism of misuse being practiced by the Waqf board, and therefore the Kerala Catholic Council, because of this Manambakam case, they are supporting the Waqf bill in which 600 people have lost their property to the Waqf there. And this is some of the criticism with regard to the Waqf Act, which is being now discussed and is being voted now in the Parliament. The Joint Parliamentary Committee has submitted some 44 amendments. Let's see how much the government hears to these criticisms and makes such changes, and what will be the reaction after the final bill, and whether the states will accept this concurrent list bought legislation, or will they bring certain changes as well. Let's look into this, like how Tamil Nadu did after the government brought the NEET law, where it brought about its own education bill to do away with the NEET examination, and it was then reserved by the governor to the president. So these are the most important points I thought I should be discussing. If you did like, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my next post. Until then, it's very happy learning.